Hello, my name is Lydia Radin, and this is a brief introduction to a tape-recorded telephone conversation between myself and former Chief Judge of the Southern District Court located at 500 Pearl Street. So this is the United States District Court, Southern District of New York, located at 500 Pearl Street, New York, New York. And Loretta A. Preska was the Chief United States District Judge. So this is the Chief Judge in the Southern District of New York. She and I had a telephone conversation, a brief one, on, Wednesday, June 1st, 2016. It's about a 2-3 minute conversation. And I had received an order from her with regard to a writ of prohibition that I had filed in the Southern District Court. Now, Judge Preska, and you'll listen to this, is a party to white-collar criminal fraud. She's a con artist. The levels of fraud, it's just mind-blowing. But let me just describe this a little bit. I filed a writ of prohibition. I didn't file something that was styled like a writ of prohibition. I filed a writ of prohibition. And I was very clear when I filed my writ of prohibition. I wrote a cover letter to the Pro Se intake unit because they're a bunch of con artists and liars too. And I explicitly said, and I'm going to quote from my cover letter, "Please be aware that this is a writ of prohibition, an original proceeding, not a complaint and not a writ of mandamus. This is a writ of prohibition due to constitutional violations of due process, equal protection, and redress, such that the lower court lost jurisdiction." So my problem is that when I went down to the courthouse, now pay attention to the timeline here, because on Friday, May 27th, 2016, me and Eric Richmond went down to the Southern District of New York, 500 Pearl Street, and we checked the docket sheet about 10 o'clock in the morning-ish. And what we found was the docket sheet was intentionally falsified. This is the same the same scam that was run in the Second Circuit. So I filed a writ of prohibition, and it actually says on the docket sheet, this would be on the docket sheet, let me give you the docket number. It's 16-CV 03291. So on the docket sheet, it says docket sheet number 2, notice of petition for a writ of prohibition. On the docket sheet as document number 3, letter. This is my cover letter from Lydia Radin filing a writ of prohibition, an original proceeding in the district court. And then when you look at the docket sheet, the title of it, it says, and this is what they wrote in, petition for a writ of mandamus. Now, it took effort and malice of forethought to type in mandamus instead of prohibition. So what they think is that I'm a stupid dumb bunny and I don't know the difference between a writ of mandamus and a writ of prohibition. A writ of mandamus is when you're trying to force or compel someone to do something, like a ministerial act. A writ of prohibition is when you're trying to stop someone from doing something because they don't have jurisdiction. So they treat you like you're a fool. You're not. So what we have here is an intentionally falsified docket sheet done deliberately, and then the many levels of fraud. Judge Loretta Preska signed an order. Oh, by the way, I got a certified photocopy of the docket sheet so that Dan Rizal, the con artist, the fraudster, the liar that my medical school paid to stalk me through life, won't accuse me of forgery. So I got a certified copy of the docket sheet where you can see that I filed a writ of prohibition, and it's it stated that at the top where the clerks wrote in petition for a writ of mandamus. This is not a mandamus. They knew what they were doing. It took effort and malice of forethought to type in writ of mandamus, MAN, instead of writ of prohibition, PRO. Then as I'm looking at, and this is what prompted me to call Judge Preska, I'm looking at the order granting my IFP application, my application to have the court fees waived. And what they did was they changed the caption. They changed it from, I am the petitioner claimant against the respondents, and they changed the caption, this is white-collar fraud, criminal fraud. They changed the caption from petitioner claimant against respondents to plaintiff against defendants. Why did they do that? Because they're shifting the burden of proof. What they did was they changed the caption so that instead of this being a writ of prohibition with a petitioner and respondents, where the burden of proof is on the respondents, they changed this to plaintiff defendants, so the burden of proof would be on me. The respondents in this writ of prohibition, and you can see this from, this is a verified writ and a notice of a verified writ. The respondents were, as I named them, the acting presiding judge Peter Tom in the Appellate Division, First Department, Cyrus Robert Vance Jr., the Manhattan District Attorney, and Eric Schneiderman, the Attorney General for the State of New York. So they changed the burden of proof because in a writ of prohibition, the burden of proof is on the respondents, and they would have to respond by if I'm putting in a verified petition, they would have to put in a verified answer, which means that, oh my goodness, they would have to put in an affidavit sworn to under penalty of perjury, and they didn't want to do that. So they also changed my name, and this took effort and malice of forethought to type in. Now, when I did a writ of prohibition, I typed in re Lydia Radin, claimant petitioner. So in, capital I, small n, re, R-E, and then my name, Lydia Radin, spelled according, this is my Christian name, spelled according to the English rules of grammar. So that would be a capital L, small I, small d, small y, small a, and then my last name, Radin, capital R, small a, small d, small I, small n. So in re Lydia Radin, the claimant petitioner against acting presiding judge Peter Tom, Judge New York Supreme Court, Appellate Division, First Department, and the clerks of court, John and Jane Does, 1 through 15, Cyrus Robert Vance Jr., District Attorney, and Eric Schneiderman, Attorney General of the State of New York, respondents. And that was changed deliberately, intentionally, maliciously, with effort and malice of forethought. That means with criminal intent. That was changed to, it took effort and malice of forethought to drop the words in re, and instead of having my name spelled as my Christian name should be spelled, it's now Lydia Radin, plaintiff, against acting presiding judge Peter Tom et al., defendants. They changed the caption. They did it deliberately. So it took effort and malice of forethought to drop the words in re and then type in my name in all capital letters as if I were a corporation, a trust, or an estate. I am none of those. So they changed the caption to Lydia Radin, plaintiff, against acting presiding judge Peter Tom et al., defendants, because they were shifting the burden of proof from the respondents to me. That's deliberate. They knew what they were doing. This is the same scam, the same con, the same fraud, the same criminal fraud that was run on me in the Second Circuit Court of Appeals. Previously, I did a writ of prohibition against Judge Ross. Judge Ross is a federal district judge in the Eastern District of New York. She was engaged in violating my constitutionally protected and guaranteed rights, and I did a writ of prohibition at the Second Circuit Court of Appeals to stop her. And they did the same con. And what they did was they falsely misrepresented my writ of prohibition as a writ of mandamus. It was not. And they applied the standards of mandamus instead of the standards of prohibition. I had to fight with the clerks for weeks and months and get no results, and I have a falsified docket sheet. So the clerks of court and the 3-judge panel are responsible for fraud, criminal fraud, for which that means that back in May 11th, 2015, the 3-judge panel and the clerks who conspired with this criminal fraud all lost jurisdiction, all their orders are void, and all the harm that happened to me after May 11th, 2015 can be attributed to the clerks of court at the Second Circuit Court of Appeals and the 3-judge panel. And that means everything that Judge Ross did after May 11th, 2015 is lawless and fraud, and more fraud. So this is the same scam, the same con that they were trying to run in the district court in the Southern District of New York. So let me just give you a little background very quickly. I was maliciously prosecuted, I never committed a crime, by dishonest attorneys, Dan Rizal, who perjured himself in 2005 and admitted that he perjured himself in 2010. John Scarfone perjured himself in 2006 and admitted that he perjured himself in 2010. Dan Rizal of Sive, Paget, and Rizal, and John Scarfone, who's Associate General Counsel at Yeshiva University, are dishonest attorneys that were paid by my medical school to lie and commit crimes against me. So in the lower criminal court in Manhattan, I'm fighting against an unlawful conviction and false arrest and false imprisonment. There was an appeal, a notice of appeal that went to the appellate term, and that should not have happened because the criminal court in the Manhattan District Attorney's Office never acquired jurisdiction. There was never an arrest warrant. There is no arrest warrant for my arrest. There are no sworn oaths enumerating the facts on which anyone would believe that a crime had been committed. So there are no sworn oaths, for example, from the complaining witnesses that enumerate the facts that would show a crime has been committed. So that's just another fraud that the Manhattan District Attorney's Office engaged in. There's no warrant for my arrest. There are no sworn oaths based on facts on which to base an arrest warrant. There is no grand jury indictment against me. I never agreed to be prosecuted with a prosecutor's information, and the only way you can be prosecuted with a prosecutor's information in New York is if you agree in open court in front of a judge with your attorney present, and this is according to the New York State Constitution. I never agreed to be prosecuted with an information. The Manhattan District Attorney's Office never acquired jurisdiction to criminally prosecute me because I committed no crime. The statutes that were used to unlawfully persecute and convict me, those statutes state explicitly that if I were stalking and harassing anyone, I would have to be stalking and harassing them without a legitimate purpose. But I, in fact, and these are the statutes say specifically without a legitimate purpose, but I have, and I continue to have, a legitimate purpose in contacting officials associated with my medical school to access and correct my records, specifically to stop federal student loan fraud against me and other crimes. So I committed no crime. Again, the Manhattan District Attorney's Office did not acquire jurisdiction. And the bogus excuse that Judge McLaughlin came up with was, oh, well, you waived. No, I cannot waive subject matter jurisdiction. So the Manhattan District Attorney's Office never acquired, and the lower criminal court never acquired jurisdiction to prosecute me. They persecuted me. Let's see, Hillary Hassler and Eleanor Ostrov at the Manhattan District Attorney's Office are dishonest attorneys. So I'm fighting them, and my attorneys are equally as dishonest and corrupt. Apparently, there was a notice of appeal that went to the appellate term. I did a writ of prohibition to stop the appellate term, and ultimately I had to do a writ of prohibition to the First Department, First Division in Manhattan. So this is the Intermediate Appeals Court, and I had to do a writ of prohibition to stop the appellate term from taking any further action to hurt me. And so I do the writ of prohibition. I had to ask the First Division, First Department for a 3-month stay because I needed to get my records from the lower criminal court. And the lower criminal court had sent the records to an archive and needed 3 months to get them. So I'm waiting for the 3 months. And in the meantime, I'm demonstrating to the judges that I'm doing my due diligence, and I go with witnesses to the appellate term, and we look through the records at the appellate term, and we demonstrate that the medical school has violated all, the Albert Einstein College of Medicine has engaged in crimes against me. Specifically, there was a subpoena. They never complied with the subpoena. We go through what records there are, and I get affidavits from my witnesses, and I provide them in various states and federal courts that show that the Manhattan District Attorney's Office and my medical school have committed crimes against me, and these are ongoing crimes. And then I take witnesses down to my attorney's office, and we go through the records there, and we confirm the same thing. In addition to that, we confirm that the harm that I suffered while I was unlawfully incarcerated at Rikers Island included the Rikers Island psychiatrists falsifying medical records, claiming I was their patient. I was never their patient. It's a fraud. So we've got crooked doctors, crooks at Rikers Island falsifying records, claiming I was their patient when I wasn't. These are at my attorney's office, and I have witnesses that came down and looked at the consent forms, which I never signed because I was never a patient, and they looked through all the ridiculous, stupid lies that Rikers Island told, which I won't go into in this audio tape. So I'm demonstrating to the First Division, First Department, that my attorneys are aware and conspired in crimes against me and taxpayers. And we've gone through the files at their office, and I have the affidavits which I've filed from witnesses. I go down to the appellate term, where the presiding judge is Judge Lowe, and again, I do my due diligence with various witnesses who signed affidavits, again, to show that my medical school has engaged in crimes against me, and the Manhattan District Attorney's Office have engaged in crimes against me, while we're waiting for the criminal court, the lower criminal court, to get my records from their archives so that I can get certified photocopies of various documents to provide to the First Division, First Department. And it takes more than 3 months. So the criminal court said, listen, there's nothing we can do. We're unable to get these records. Go tell the First Division, First Department that we need another 30 days at least. So I go down to tell the First Division, First Department, and to ask for the stay to be continued for another 30 days. And the presiding judge, oh, by the way, the Manhattan District Attorney's Office does not oppose. The Attorney General's Office does not oppose. And the acting presiding judge, Peter Tom, says no. So I am being punished now because of the criminal court's inability to provide me with the records from the unlawful criminal proceeding. Well, that's a violation of my constitutionally protected and guaranteed rights to equal protection, due process, and redress of grievances. So, and Peter Tom probably was goaded into this decision by one of the nasty law clerks down there. So he wants to punish me, pretending that, I'm somehow remiss. I am physically disabled with spinal injuries and have some very serious health problems. So, of course, acting presiding judge Peter Tom wants to punish me and victimize me even more. So I'm not going to have this. I go down to the federal district courthouse and I put into place a writ of prohibition because acting presiding judge Peter Tom has violated my constitutionally protected and guaranteed rights, and I should not be victimized and persecuted even more just because the lower criminal court was not able to get me my records from their archives within 90 days, and they needed an additional 30 days. So I should not be punished for that. The First Division, First Department lost jurisdiction by violating my rights to due process, equal protection, and redress of grievances. I go to the Federal District Courthouse, 500 Pearl Street, and I file my writ of prohibition. And because I was scammed by the Second Circuit Court of Appeals, I was very clear in my cover letter to the pro se intake unit that this was a writ of prohibition. I explicitly stated in my cover letter, and I'm quoting from my cover letter, please be aware this is a writ of prohibition, an original proceeding, not a complaint, not a writ of mandamus, a writ of prohibition due to constitutional violations of due process, equal protection, and redress, such that the lower court lost jurisdiction. And so what happens in the Southern District Court, in the Federal District Court? I also say I don't want to deal with the pro se staff attorney because they're a bunch of con artists too, and I'll get to that later. But the pro se staff attorneys also engage in deceptive practices and in the unauthorized practice of law. But I'll get to that later. So what happens at the district court? Well, the same con, the same scam, they're a bunch of con artists, and they're about to run the same scam that they ran on me at the Second Circuit Court of Appeals. So what they do is they falsify the docket sheet, and they try to falsely represent my writ of prohibition as if it was a writ of mandamus. It's not. And they change the caption to change my writ of prohibition to a complaint. It's not a complaint with a plaintiff and a defendant where the burden of proof is on the plaintiff. It's a writ of prohibition with a petitioner and a respondent where the burden of proof is on the respondents. That would be acting presiding Judge Peter Tom in the First Division, First Department, and he would have to respond to my writ of prohibition by a sworn affidavit and explain to the Federal District Court why he would refuse me, the innocent victim of these crimes, an additional 30 days so that the lower criminal court could retrieve my records from its archives. He has no excuse. He ran roughshod over me and my rights. And now what you have is I am going to a federal district judge, and the person who took charge of this case was Loretta A. Preska, and I'm reporting to her misapprehension of a felony. That what the state court judge did, what Judge Peter Tom did, is a wrong. It's a great wrong. And what does Judge Preska, the federal district judge, do? She aids and abets the criminal activity. She covers up for the state court judge. So now she is demonstrating irrefutably that she's involved in misapprehension of treason. So we've got one judge doing wrong and another judge covering up for that judge, undermining our constitutionally protected and guaranteed rights and undermining our republic. And so what you have here is a seditious insurrection by judges. This is the domestic enemy, the enemy within. So I call when I got, so that's sort of the brief, not so brief overview, so you can orient yourself to this. So when I got this order, you know, I'm not a boob. I'm like, oh, okay, you've done this before. You did this to a friend of mine out in the Midwest who in a federal district court filed a writ of prohibition, and they changed the caption to plaintiff defendants so they could shift the burden of proof so that the respondents would not have to reply by a sworn affidavit. They know what they're doing. They're con artists. So this looks like this is a pattern and a practice, and they try to take advantage of us pro se litigants because they think we're stupid, and they try to railroad over us and inflict all kinds of irreparable harm on us. So when I got this order from the judge, I call her up. This was on June 1st, 2016. So let me get the timeline so you can see exactly the criminality here by Judge Preska, who's covering up for the judges in the lower state court. And so Friday, May 27th, 2016, me and Eric Richmond go down to the district court, and we see, you know, we try to talk to the pro se office, and we see the intentionally falsified docket sheet, and we get the certified photocopies. And so on Friday, May 27th in the morning, this is when this is happening. Then we go into, Eric and I leave the courthouse about 10 o'clock, 10:30-ish. This is on Friday, May 27th, 2016. We're going into the Memorial Day weekend, so it's Saturday, May 28th, Sunday, May 29th, Monday, May 30th. On Tuesday, May 31st, 2016, and this is unbeknownst to me when I called Judge Preska. Judge Preska runs to her office on May 31st to falsify a judgment against me. I'm going to reject this judgment because it's void for fraud. It's criminal fraud. And we'll get to this later. So I don't know that she's done this order on May 31st, 2016. I call her on Wednesday, June 1st, 2016, and this is the telephone conversation that I have with her where I say, hey, Judge Preska, the docket sheet has been intentionally falsified. I filed a writ of prohibition, not a writ of mandamus. Why is the docket sheet saying writ of mandamus? I know it's because what they're going to do is the same scam that they ran in the Second Circuit Court of Appeals, where they falsely represent your writ of prohibition as a writ of mandamus. They apply the wrong standard, and then they dismiss your writ, and they do it because it's a criminal fraud. They don't want the respondents to respond because when you do a verified writ of prohibition, there has to be a verified answer. That means that the answer has to be sworn to under penalty of perjury. So they're all afraid of doing that because they're all a bunch of con artists and criminals. So I call up on June 1st, 2016. I call up Judge Preska. She answers her phone, and I say, hey, there's something really wrong here because this order that you sent to me on May 19th, 2016, where you're giving me leave to proceed without, you're waiving the court fees, you've changed the caption here. Okay, that's a criminal fraud. And this has happened before. The first time I met Mr. Gerard Clark, who's the nephew of a very famous civil rights activist, Virgil D. Hawkins. First time I met him, I was in the federal district court, and two businessmen were coming up from state court. The caption on their complaint in state court was changed so that the state court judge could dismiss their complaint unlawfully. So apparently this is a pattern and practice of cons, dirty tricks. I guess all these judges go to dirty trick school. So, you know, they know what's the dirty trick today, what's the con we're going to run today. So the first time I met Gerard Clark was in the Eastern District Courthouse, and online with us were two business owners who were coming up from state court because their civil rights had been violated, because in state court the caption was changed on one of their complaints. So I guess this is a standard dirty trick. They changed the caption in my writ of prohibition, and this is the 2-minute and 51-second telephone conversation that I have with Judge Preska. I don't know that she's run into work on Tuesday, May 31st, so she could dismiss my writ of prohibition, which, by the way, this is all fraud, and more fraud. It's void for fraud. I'm rejecting this order for fraud. I don't appeal fraud. I collaterally attack it, and I prosecute her for fraud, and the law clerks. And the law clerks and the court clerks who committed this fraud have no immunity. The judge has no immunity. Rooker-Feldman does not apply to this lower state court, because the lower state court is engaged in violating my constitutionally protected and guaranteed rights. So Rooker-Feldman does not apply. I'm going to federal district court to stop the violation of my civil rights. So in any case, you're going to hear me talk to Judge Preska, and I'm going to say, hey, I'm looking at this order that you sent me, and the caption's been changed. That's a criminal fraud, and it's done intentionally, deliberately, willfully, with malice aforethought, with effort. It takes effort to do this. They knew what they were doing. So you're going to listen to me, say, hey, Judge Preska, the caption has been changed, the docket sheet has been falsified, and this is the con that you're going to run. You're going to treat my writ of prohibition as if it was a writ of mandamus, apply the wrong standard so you can dismiss it. This is the same scam that was run on me in the Second Circuit Court of Appeals. Now, I'm calling her in good faith because I have not realized yet that on May 31st, she wrote an order unlawfully dismissing my writ. So when I call her on Wednesday, June 1st, 2016, she knows what she's done the day before. So when she says I'll look into it, she's lying on the phone to me. She signed this order. She didn't say, oh, Miss Radin, I signed an order yesterday dismissing your writ. She didn't discuss that with me. She got off the phone real fast, and now she's dodging me, but I have a very interesting phone conversation with her law clerk. So Judge Preska is a criminal fraudster. She's a con artist. She's dishonest. She knows what she's doing. So when I was on the phone with her on Wednesday, June 1st, 2016, she didn't say, oh, Miss Radin, I signed an order against you on Tuesday, May 31st, just yesterday. And she didn't say, oh, yeah, look at this order. The order also has the caption that has been falsified. Instead, she made up some bogus fabricated ruling that I was stylizing an action as a notice of a writ of prohibition. I wasn't stylizing this. This is a writ of prohibition. But the language that she used is telling, because that's the same bogus language that Jean T. Schneider used in landlord-tenant court. And I'll get to that in subsequent episodes. Right now, let's listen to Judge Loretta A. Preska when I question her about, what are you doing here falsifying the docket sheet? I filed a writ of prohibition, not a writ of mandamus, and why are you changing the caption to shift the burden of proof? Because you're trying to take advantage, run a criminal fraud on me, a pro se litigant. So that should be enough of an introduction to this telephone conversation. Thank you for your attention. And here we go.
It's Judge Preska.
Hello?
Hello. Yes.
Yes, I'm trying to reach Judge Preska.
Yes. Who is this, please?
My name is Lydia Radin, and I'm calling about an order that you sent me.
Yes.
I got a few problems with it. I was doing a writ of prohibition against a state court judge who was acting unlawfully, and my writ of prohibition is misrepresented on the docket sheet as a writ of mandamus. It's not a writ of mandamus, it's a writ of prohibition.
Okay, could you give me the number of your case, ma'am?
Surely. This is Judge Preska?
It is.
It's wonderful that you answer your phone. I thought I'd get your law clerk. Thank you so much.
Yes, ma'am.
It's 16-CV3291.
Great. I'll go and take a look at it.
And the other quick thing, thank you so much for your kind attention, I appreciate it, is that the state court is continuing to act, even though I put in a request for a stay. And I'm going to try to say this as politely as I can, but I spoke to the clerk at the state court today, and they basically thumbed their nose at me and said, well, you asked for a stay, but you didn't bring us the stay order, so screw you, we're going to continue to act. And they are. I'm like, you really can't do that. I'm a pro se litigant who's physically disabled. I'm dealing with trying to avoid very serious back surgery. I have Social Security disability. I may have a potentially life-ending medical condition, and I did the paperwork well enough for all of you purportedly responsible people in positions of public trust not to railroad over me, but they want a stay order from you. So could you be so kind as to issue a stay order, and I will hand deliver it to them to stop them from their railroad training over me?
I will take a look at it, ma'am, and see what has to be done.
Okay, thank you. The other reason why I'm bringing this to your attention too is that the caption was changed on your order, and it says Lydia Radin, plaintiff against acting presiding Judge Peter Tom et al. Defendants. That's not what I wrote. I wrote in re Lydia Radin, claimant petitioner against respondents. And when the caption is changed, that's shifting the burden of proof. The burden of proof in a writ of prohibition is on the respondents to respond by sworn.
Okay, I'll take a look at that as well.
Okay, thank you.
Yes, ma'am. Thank you. Bye-bye.
Bye.